And ladies and gentlemen, today this mega exclusive is the start of my program tonight. With me this evening, without doubt, one of India's foremost jurists, former Solicitor General, King's Counsel, senior advocate, shakes up the court with every appearance. Harish Salve represented lead lawyer for the members of the Shinde faction, the real Shiv Sena in the Supreme Court. You're the man of the match, Mr. Salve. So congratulations to you and the judgment, first of all. Many congratulations.
Thank you. But the man of the match is the Chief Justice who wrote the judgment. So
yes, of course, you'd say that.
Supporters.
Yeah, but you know, I remember speaking to you some time back, and I watched your quote-unquote performance in the court, if I may say so, if you don't mind. You really
now we are all on YouTube, so I suppose you can call.
Yeah, the whole thing was televised, and I found it incredible, Mr. Salve, that you brought down the entire case to one single point. Rather than argue on technicalities and this and that and dates and numbers, you really brought up the issue of jurisdiction. For those who may not have seen the basic argument you made in this case in the Supreme Court, could you in brief explain to our viewers what your central contention was?
See, the point is there were two big issues. There is a judgment of the Supreme Court which had said that the Speaker should not get into deciding disqualification petitions where his own disqualification is pending. Now, that judgment used phraseology which perhaps suggested that the Speaker was rendered powerless, which becomes a very extreme proposition. We relied on it in our writ petition in round one, challenging the disqualification notices by the Speaker to the Shinde faction. But there was another important issue there, that the Speaker had given only 3 days' time for a reply. Even under the rules, 7 days or 10 days has to be given, something like that. The Supreme Court gave 10 days' time to file a reply. They did not accept the principle that the Speaker cannot initiate proceeding. They were yet to hear that point. In the 10 days' time which the Speaker gave to file the reply, political events dramatically evolved, ending with Uddhav Thackeray's resignation. It was in that hiatus, everything happened. So I argued that reconsidering that judgment in that Nabeem Rabia case really doesn't arise in this case, and the court had accepted it doesn't arise in this case. But because it's such an important question of law and it arises frequently, they referred it to 7 judges, acknowledging that it didn't arise. And one of the points which I argued, which the court, I don't know, I have not read the judgment, did not deal whether they did or did not. Mr. Sibal, who argued for a reference to a larger bench, and Dr. Singhvi, who argued for reference to larger bench, were appearing in 2 cases where this judgment was relied upon. So they were arguing a case on which they rely upon is wrongly decided. So it was a very curious situation. Anyway, the court has referred it to the larger bench. So that was one dimension. The second, all the other issues about whether the governor should or should not have called, whether this should have happened, that should have happened, according to me, were all academic. Because at the end of the day, 2 things happened. Uddhav Thackeray resigned. Upon Uddhav Thackeray's resignation, Shinde threw his hat into the ring. The governor called him, swore him in. Shinde then had a vote of confidence and was voted in. Nothing remained to be decided. Now, should the governor have called Uddhav Thackeray to prove his majority on the floor of the House? We argued there was nothing really wrong in that because the governor should enter the floor. Supreme Court has, I believe, from what I heard of the judgment, said no, he should not have called Uddhav to prove his majority. He should have asked Fadnavis or somebody to move a no confidence or something like that. I haven't read the judgment. Now, that's only a question of should he be asked to prove or should somebody challenge? The consequence would have been the same. That's why ultimately it's only a guidance for the future that the governor, rather than invite somebody to prove the majority, should leave it to somebody to defeat the majority.
No, your argument was brilliant. because brilliant, absolutely brilliant. And that's what I call, you know, the typical Harish Salve school of argument. I think one day chapters will be written about this and be studied in law schools, that you bring everything down to one point. And I found it marvelous because, you know, I really wanted to be a lawyer. I didn't get a senior like you to train me. But you said it would be extremely perilous for this court to embark on this journey of deciding what should happen in the political space. You almost, did you feel at that point making that argument that you were overstepping? That you were really telling the court? I mean, Mr. Salve, let me put it simply to you. I've heard Mr. Jethmalani do it sometimes, you know, in the past, where he used to really come and tell the court, my lords, with lordships, with all respect, you can do this and you can't do this. But the lawyers say it, but you actually said it would be perilous for the court to go into the political domain. You said that the court should not venture into a hypothetical question of a flaw test that did not happen. And that is what the court has said now. So the court has in a way sort of agreed with your fundamental argument, isn't it? I mean, that's my first question. Second question, having that point having been made, what do you make of what the opposition is saying now, what the Uddhav camp is saying now?
Let's take both the points step by step. Firstly, yes, why I said it is perilous to assume what would have happened, it's not merely a question of numbers. We do not know what else would have transpired had Uddhav decided to pick up the gauntlet and ask for a floor test. Point number one. Point number two, another layer of uncertainty is added by the fact that this is a coalition government. I mean, who knows when a coalition partner would have had a sudden pang of conscience and said, no, I cannot support Thackeray, because a large part of his party is not with him. I mean, we don't know. So that's why I said it is perilous for the court, because this is hardcore politics. This is perilous for the court to speculate on what would have happened. And I think they've accepted that. And the second bit about which parts have gone against, there are 2 or 3 points which the court has made. And this is, I don't see I have not seen what comments people have made, but let's be very clear. They have clarified the law on 2 or 3 subjects. We have always had this question of political party versus legislative party. The whip is appointed by the legislative party or by the political party. The Supreme Court has clarified it is appointed by the political party. So that's why the appointment of a whip has to be by the political party. Now, that's a question of law which they have answered. The speaker has not been removed. Nothing has been said which doubts his authority. The second question which they have addressed is about how the governor should conduct himself. Should he wait for a no confidence to be brought, or should he invite a vote of confidence? They have said, don't invite a vote of confidence. Let a no confidence be brought. That's again a matter of constitutional interpretation, and which the court has guided for the future. These are the 2, and the third is they have guided the election commission saying, you should act not on the political party, not on the legislative party, but on the political party. In other words, they say, you always go by numbers, political numbers. You don't go by legislature and counting of those who are in the elected to office. These are questions of law which the court has answered, which are guidance for the future. As far as the present case is concerned, nothing arose. Since 5 judges were sitting, they heard arguments. They thought that it makes sense to lay down these principles of law, because these questions do tend to arise in the future.
Which brings me to another point, Mr. Salve. During the hearing, you said that, quote unquote, making assumptions would be hazardous for a constitutional court. You said that everything is academic. Courts can't go beyond a point. Now, Mr. Salve, am I wrong in assuming that of late, various political parties are trying to drag the courts to intervene in political matters where they have failed as politicians? You see, and do you agree with this assessment?
Arnab, you know, I always bring this up. Today, politicians do 2 things. In one breath, they complain about the court usurping jurisdiction and trenching into areas where it doesn't belong. and in the next breath, they invite court to decide all sorts of questions. This trend started in Ayodhya when the Congress government, Narasimha Rao government was in power, and the Attorney General, late Mr. Milan Banerjee, got up and told the court that my armed forces are waiting for your lordship's command. And Justice Venkat Chalaya very tersely told him, armed forces are commanded by their generals, not by Supreme Court. Why did he say it? Because the difficult decision on whether to use force on the Kar Sevaks or not, they wanted the Supreme Court to take. So every time it's a controversial thing, you want the Supreme Court to decide, but every time the courts, then what happens? The courts starting widening their own jurisdiction. The judges get into more and more areas. Then you grumble that the courts are overstepping their bounds. So, there is a kind of a tension between what you want courts to do when it suits you, and then you criticize courts for having done things which are outside their traditional jurisdiction.
Last question. If Uddhav had not quit, would things have been different?
I doubt. I really doubt. Because what would have happened if Uddhav had not quit? If Uddhav had come onto the floor of the House and been defeated.
Yeah.
But the Supreme Court have said that he was called and he lost. But because he should not have been asked to prove, and it should have come as a vote of no confidence, the consequence would have been different. Any such judgment would have been deeply flawed.
Absolutely. Well,
but that didn't come to pass.
Well, this is a masterclass. I think I unfortunately never got to see you in court when you were arguing in my case, which is now, by the way, being quoted by the very people who stood against you in my case. But I think for all law students, they should see the way you argued in this case. It was just exemplary. And I thank you very much, and many congratulations once again, Mr. Salve, for joining me this evening from London. Thank you.
Thank you.